Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 78th lecture series. 78. This is happening because of your collaboration, because of your commitment, dedication. This is ongoing and this will go and see centuries after centuries, dear friends. Reason is the object of AAA is to dispel the darkness of ignorance and light the lamp of knowledge. This knowledge there is no end to the knowledge. It is like an ocean. Our efforts may be very less, but our goal will take long time to reach. With this note, it is our regular practice. We recite the preamble of the Constitution of India as our soul and as our goal, because we have a commitment and sentiment towards the preamble. Preamble our unity, preamble our identity, preamble our breath, preamble our health. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. We have gathered here to discuss about a very important topic that is related to serial number 77 of the revised leading cases in the AOR examination, that is Article 370 of the Constitution of India related to state of Jammu and Kashmir, abrogation of Article 370. With respect to this topic, we have already delivered a lecture, that is lecture number 76 and 77, dealing with overview of the entire judgment and how the matter was referred to the Constitution bench, that is led by Honorable Chief Justice Dr. D.Y. Chandrachud, then he was. Now today, we are going to discuss about the conclusion of the judgment. It is really running to more than 280 pages to arrive at that conclusion. These are all ratio decidenting, brief facts, historical context, submissions made by the both sides, and answering to those issues. And ultimately, the authoritative pronouncement was made in the conclusion. Now, due to paucity of time, we will be dealing only with the conclusions, dear friends. The name of the case and the reported citation I will tell you. Article 370 of the Constitution in re. It is reported in 2024 volume 11 Supreme Court cases, page number 1. Let me take you to the conclusion straight away. Before going to the conclusion, one thing that we must keep it in our mind. Article 370 is a special status given to the state of Jammu and Kashmir. What is that special status which was not enjoyed by other states? They had their own constitution, Constitution of Jammu and Kashmir. They had their own flag. The state can enact a law on various subjects, including the union list, including the state list. There are only few exceptions where the state of Jammu and Kashmir cannot enact a law on external affairs, communications, on defense. So they were enjoying absolute privilege, and the Constitution of India is not entirely applied to the state of Jammu and Kashmir. Only partly it was applied. So these were all the special privileges were given to the state of Jammu and Kashmir from the date of adoption of our Constitution of India. Now that special privilege has been taken away by the Parliament, by issuance of constitutional orders by the President of India. Now the petitioners challenged that abrogation of Article 370 is unconstitutional, violative of certain rights before the Supreme Court of India. Now the Honorable Supreme Court has held abrogation of Article 370 is valid. So taking away these special privileges provided to state of Jammu and Kashmir is valid. So this is what the decision of the Supreme Court. Now let us see the conclusions one by one. How do they say that abrogation of Article 370 is valid? By keeping this in our mind, goal is fixed. Article 370 is valid. How to reach the goal one by one? Let us see the conclusions. Firstly, in my humble opinion, dear friends, each conclusion is the result of 286 pages and 527 paragraphs. That means behind each word there is a world. So we have to go very carefully and understand in a depth manner. In view of I am reading para 531, dear friends. In view of the above discussion, the following are the conclusions. 531.1. The state of Jammu and Kashmir does not retain. Now the question before here is, let us understand the question. Number one question is whether the state of Jammu and Kashmir has ever enjoyed sovereignty. What is the meaning of sovereignty? There is no force, external force or internal force to dictate. They can decide on their own affairs. So whether Kashmir enjoyed the sovereignty, the answer given by the Honorable Supreme Court is no. There was no sovereignty at any point of time attached to the state of Jammu and Kashmir. To arrive at that, the Honorable Judges, the Supreme Court has discussed about the preamble of the Constitution of India. The preamble says, we, the people of India, having solemnly resolved to constitute India into a sovereign, not any other state as a sovereign. So India is a sovereign, and state of Jammu and Kashmir has entered into IOA, Instrument of Accession, and they made themselves as a part of India. Article 1 says, India, that is Bharat, shall be union of all states, which includes state of Jammu and Kashmir also. So therefore, there cannot be two sovereignty. There is one sovereignty, that is India, and state of Jammu and Kashmir is a part of India. Now, whether this Article 370 is a special privilege given to state of Jammu and Kashmir, does it amount to sovereignty given to the state of Jammu and Kashmir? That is the next question. The Honorable Supreme Court has categorically held what is Article 370 is only the special privilege. It cannot be equated to sovereignty. Though it may not asymmetrical federalism, because those special privileges are not enjoyed by the other states, but special privileges cannot be equated to sovereignty. This is what they have said. Now let us read what they have said. The state of Jammu and Kashmir does not retain any element of sovereignty after the execution of the IOA, Instrument of Accession, and the issuance of the proclamation dated 25th November 1949. You all know 26th November 1949 we adopted our constitution, that is being celebrated as a Constitution Day, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. I repeat, the state of Jammu and Kashmir does not have internal sovereignty which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. So the decision is, state of Jammu and Kashmir never and ever had sovereignty at any point of time. That is the first point. Point number 2. The petitioners before the Honorable Supreme Court who challenged the abrogation of Article 370, what did they do? The petitioners did not challenge the issuance of the proclamations under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. So they did not challenge when the governor dissolved the assembly. The petitioners did not challenge the action of the president when he promulgated emergency in the state of Jammu and Kashmir. They kept quiet. But when the petitioners woke up, they woke up when the president issued constitutional orders, 2 orders. President issued 2 orders, Constitutional Order 272 and 273. Constitutional Order 272 says, para number 2 of Constitutional Order 272 says that entire Constitution of India will be applicable to the state of Jammu and Kashmir. Meaning thereby, the Constitution of Jammu and Kashmir becomes redundant. By one stroke, 75 years of history is rewritten. Coming to the second presidential order 273. 273 says abrogation of Article 370. Special privilege provided to the state of Jammu and Kashmir was abrogated by 273. So these petitioners challenged the governor's action under Section 92 of the Jammu and Kashmir Constitution and president's promulgation of emergency after issuance of constitutional orders. So it was a late reaction by the petitioners. So the challenge to the proclamations does not merit adjudication because the principal challenge is to the actions which were taken after the proclamation was issued. So actual challenge came only after issuance of presidential orders 272 and 273. Before that, president's imposition of state emergency was not challenged, and governor action under Section 92 of the Jammu and Kashmir Constitution was not challenged at that point of time. That is the second point. Dear friends, each point we will be moving towards the goal. The goal is abrogation of Article 370 was valid. To arrive at that goal, each point we are moving towards the goal. Number 3, third point. The exercise of power by the president after the proclamation under Article 356. The exercise of power by the president after the proclamation under Article 356 is subject to judicial review. We all know that Article 356 deals with presidential power to impose state emergency. Whether President's promulgation of state emergency is subject to judicial review? The answer is yes. Whether President has acted in a mala fide or a bona fide? Whether President's action was extraneous exercise of his power or not? So his presidential action is subject to judicial review. And you all know that judicial review is a basic structure of the Constitution of India. Parliament cannot take away the right of judicial review at any point of time by even by virtue of Article 368. Dear friends, from this you can understand the power of the judiciary. From this you can understand the power of the judiciary is given to protect people of India. Fundamental rights guaranteed to the people of India. So that is most important. It is not which organ is bigger or which organ is greater. The only is which is greater is the people of India. All the other organs, legislative, executive, judiciary, are working for the welfare of the people of India. The system is existing for the people of India. The people of India is not existing for the system. We must remember that. And that is what the preamble says. We, the people of India, given to ourselves, we must remember, all Indians are the custodian of the Constitution of India. It is not that we should have a designation as a justice to protect the Constitution. You can have a designation that is being an Indian is itself good enough to protect the Constitution of India. The exercise of power by the President after the proclamation under Article 356 is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of the proclamation. Why the President declaring state emergency? And what is the nexus, reasonable nexus for the proclamation? These two things should be there. For declaration of proclamation, there should be reason. Immediately elected government cannot be dissolved. So, the exercise of power by the President, the first element is must have a reasonable nexus with the object of the proclamation. The person challenging now, again in the same point, if a petitioner is challenging that presidential proclamation of state emergency is bad, what he has to establish before the court of law? Two elements are to be established by the petitioners. Firstly, the person challenging the exercise of power must prima facie establish that it is a mala fide. The action of the president is mala fide. He has not acted in good faith. That is the first point. Second is, president has acted in an extraneous exercise of power. That means the situation did not warrant the promulgation of emergency, but it is irrelevant to invoke presidential rule. So extraneous exercise of power, meaning thereby arbitrary exercise of power. These two elements must be established, prima facie established, that it is mala fide or extraneous exercise of power. Once the petitioner establishes this before the court of law, once a prima facie case is made, the onus shifts to the union to justify the exercise of such power. So from this, what we understand, the third point is, the president's promulgation of emergency is subject to judicial review. But it is very, very limited. The scope is limited. So what are those two windows under which the Supreme Court or the High Court can go into the judicial review is, prima facie, the petitioner must establish that the president has acted in a mala fide or extraneous exercise of his power. Once prima facie case is established and the court is convinced, now the court will look at the union and give an opportunity. What do you say as a union government? Now the onus shifts to them to establish that the president has not acted in a malafide manner, has not exercised his power arbitrarily. It was not an extraneous exercise of power that they need to establish. This is the third point. The fourth point, the power of parliament under Article 356 1B, that is presidential power to impose emergency, to exercise the power of the legislature of the state cannot be restricted to law making power, thereby excluding non-law making power of the legislature of the state. Such an interpretation would amount to a reading in a limitation into the provision contrary to the text of the article. I repeat, dear friends, the power of the parliament under Article 356 1B to exercise the powers of the state cannot be restricted to law-making power, thereby excluding non-law making power of the legislature of the state. Such an interpretation would amount to reading in a limitation into the provision contrary to the text of the article, meaning thereby, once the state legislature is dissolved, presidential rule is there, parliament has power to make a law to manage the affairs, but it cannot be interpreted in such a way that president cannot issue the orders, constitutional orders. We cannot interpret in such a way. They can not only make law, but also the constitutional orders can also be made. That is the power of the president. And you cannot restrict such a power which is not restricted by the article itself. That is contrary to the interpretation of the provisions. Fifth point, it can be garnered from the historical context for the inclusion of Article 370. It can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution, that it is a temporary provision. See, when you see, the petitioners argued that Article 370 cannot be taken back. It has to continue. It is like permanent in nature. It is sovereignty vested with the state of Jammu and Kashmir. It cannot be taken away just like that. That was their argument. But what was the conclusion by the Honorable Supreme Court? Please look at Article 370. It falls under Part 21. What is the heading of Part 21 of the Constitution? It is temporary, transitional and special powers. TTS in short, temporary, transitional or special powers. So 370 falls under TTS, that is Part 21. Therefore, that itself indicates that it is temporary in nature. So that is what the Honorable Supreme Court has held. It can be garnered from the historical context for the inclusion of Article 370 and the placement of Article 370 in Part 21 of the Constitution, that it is a temporary provision. Now, the sixth point is the power under Article 370 Clause 3. I request each one of you to understand this judgment. You should be thorough with one provision, that is Article 370. More particularly, Article 370 Clause 1D and Article 370 Clause 3. If you are not going through the entire provisions of the Constitution of 370, you can go through these two provisions, dear friends. Article 370 1D, Article 370 Clause 3. Very important. The power under Article 370 Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. This is core subject of the Constitution Bench judgment. The power under Article 370 Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370 Clause 3, which empowered the Constituent Assembly to make its recommendations, cease to exist. It did not affect the power held by the President under Article 370 Clause 3. We must understand what is 370 Clause 3 and the proviso. 370 Clause 3 says the President may, by public notification, can declare that Article 370 will cease to operate. That is the power provided to the President. Provided there is a proviso, there is a precondition, provided that there is a recommendation given by the Constituent Assembly. But what is the purpose of the Constituent Assembly constituted in the state of Jammu and Kashmir? To frame the constitution for the state of Jammu and Kashmir. Once the constitution came into force, the purpose of the Constituent Assembly got dissolved. It is no more in existence. It is dead. So when Constituent Assembly is dead, it is dissolved, it cannot give recommendation to the President. Therefore, such recommendation was not given for the last 75 years, which was not in existence at all. So, there cannot be a recommendation from the Constituent Assembly. So, those letters are dead letters. Proviso are dead letters. But, what is the power given to the President? The President can unilaterally, by notification, can declare that 370 shall cease to operate. That is unilateral power. That is existing from the day one, even now. That is what they have held. Right now, let me read, you will understand. The power under Article 370 Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. Dear friends, 370 Clause 3 and the proviso, Lordships applying their wisdom, understanding and analyzing the submissions made by both the sides, they put a big wall. Proviso, they say it is dead. Constituent Assembly is dissolved. They are not existing because they have served the purpose. But other main provision, they are saying it is existing. It continues to exist even after dissolution of the Constituent Assembly. This is where the honorable judges, the Supreme Court being the custodian of the Constitution, their interpretation plays a vital role. Who is the final interpreter of the Constitution of India? The Honorable Supreme Court of India. That is comprising of honorable judges. Previously they were lawyers like us. So therefore it is we the people are the custodian of the Constitution, dear friends. Let us not underestimate the power of lawyers. Lawyers are the warriors and we have no barriers except in our mind. Except in our mind. Please, we will feel our infinity. We are boundless. We are highly intelligent people. We should think ourselves, what is wrong in it? There may be a sin when we are weakening ourselves, when we feel that we are weak. By feeling weakness, it amounts to death. We should always feel we are the strongest persons. We can do wonders and we can recite as a prayer, lawyers or warriors, we have no barrier. Right? So let me read this, dear friends. The power under Article 370 Clause 3 did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. So they are saying provision is existing. When the Constituent Assembly was dissolved, what is the effect of dissolution of Constituent Assembly? It was only the transitional power recognized in the proviso to Article 370 Clause 3, which empowered the Constituent Assembly to make it recommendation cease to exist. So only the Constituent Assembly, which is supposed to make recommendations, it got dissolved because it ceased to exist. It did not affect the power held by the President under 370 Clause 3. So, this is a beautiful interpretation, dear friends. Each interpretation moving a step forward towards one goal, that is abrogation of Article 370 was constitutionally valid. Constitutional order passed by the President 272 and 273 are valid. That is the final conclusion, and each step moving forward towards the goal by upholding Article 370. Thank you so much for your patience hearing, dear friends.